All right, y'all. It's popping. It's on and popping. You know what it is. Peace to the gods. Peace to the gods. Yusef here. Let's get it. How everybody doing today? Let me do a sound check real quick. Sound check. What's going on? I know some people be getting like irritated with me doing a sound check, but I gotta do a sound check, man, because I'm really not no like type of I need to get me a what the hell's man commercial and shit. All right, we're good. We're good. All right, we're good. We're good. We're good. All right. Peace to the gods. All right. Today we're going to get into a discussion. Oh, wait a minute. I ain't send that thing off, did I? Hold on, y'all. I was supposed to send this email off. Somebody called me and I forgot to send it off. Where's it at? Oh. We're going to get into discussion today. I'll forget it. I ain't worried about it. We're going to just get to it. Where we at? Let somebody else do this. We're going to talk about the Clerks Praxis today. The Clerks Praxis. Now, why am I going to talk about the Clerks Praxis today? You know, yesterday we were having the discussion about why they don't like secure party, and I was showing you examples of all this is commercial, but really it's in the nature of admiralty. Now, to understand why you need to do a secure party process, you got to understand the jurisdiction that the court is operating under and essentially the jurisdiction of everything in society, period. The admiralty jurisdiction is the law of the sea. You'll hear people say that is the law of the sea. What does that have to do with on land, Yusef? Now, this is the biggest deception that is going on right now, is they tell you that it is the law of the sea. So in your mind, you got thinking, okay, this has nothing to do with ships and boats and things like this. This nigga's crazy. It don't have anything to do with what's going on the land. I can hear the attorneys right now, because they're illiterate. They only know what they were taught in law school by their liberal professor who dumbed them down and only got them just following procedures off statutes. You know, they don't know. You know, so if you're an attorney, I'm about to educate you on some things too and give you some case law for you to look up as well, because you're always caught, you know, saying that, you know, this is the law of the sea. You know, it's the law of the sea, you know. The jurisdictions that are outlined in the Constitution for the United States of America, there are four. Two of them are kind of similar, and that is common law, equity, admiralty, maritime. Admiralty and maritime both being similar, having to do with maritime commerce or the sea. I remember an officer, he came to my cell and he was telling me that. He said, y'all talking about this admiralty stuff, that's the law of the sea. And it was funny to me, an officer who's a security guard basically trying to educate me about the law and didn't understand that. But what you have to understand that admiralty is about the subject matter, not the locale, okay, that we're going to get into. 90% of commerce does go over the sea, but there's a 10% that is connected that goes over land, which are trucking, things of that nature, and all the other things that are involved, that we're involved in. Today, we're going to review a document called the Clerks Praxis. When I first studied the Clerks Praxis, it took me approximately 6 weeks to study this document. I was in solitary confinement. Somebody sent it to me. I was able to read, because yesterday when we read that document, the Gene Keating transcript, I had that when I was locked up. So after reading that, I called my friend on the street and I said, hey man, can you get a hold of a copy of something called the Clerks Praxis? He was able to copy it for me, and he actually sent me the whole thing in jail while I was in solitary confinement. It was delivered to me. While in solitary confinement, I took the time to slowly investigate this. I was right across the hall from the law library. So what I was doing is I was using American jurisprudence and studying statutes, United States codes annotated, as well as the official code of Georgia annotated. And I was comparing and contrasting and juxtaposing what I was reading under the Clerks Praxis with what I was seeing in the statutory codes under the in the law books. Because what I understood is that these people don't make up anything. All the things that they do is based off of history. They're not that smart. All right? They study what their ancestors do, and they perfect what has already been put in place. So I understood that there had to be some sort of basis for what they were doing. So in studying the Clerks Praxis, I was able to decipher the old terminology that was used and see how it was being plugged in into the new. And hopefully today, I'm probably not going to be able to do it in one day. The Clerks Praxis is broken up into 3 parts. We're going to try to get through the first part today, and it'll probably take 3 days to go through all parts. All right, but the first part is the history of it. All right, how the admiralty courts and the common law courts battled. You'll hear a lot of people keep talking about common law courts. I don't think a lot of them really have an understanding of it, but common law and admiralty have been at war with each other for a very long time, for centuries. Sometimes the common law courts would dominate, and at other times the admiralty courts would dominate. The admiralty courts were preferred because it was a way that the barons and lords and everything who'd have their own court system could make money. This is all about making money. You're going to see something that in here talking about the rapacious appetites of these people. Rapacious means greed, okay? So we're going to look at this today. We're going to look at the Clerks Praxis. And let me see. I got all my stuff set up today, I think. Let me see. I didn't get a chance to set everything up. But I think we can get this Clerks Praxis up and going. All right, so I hope y'all are ready to roll. It's been taken down off a lot of websites. I think that is very strange. I think that's very strange how many. All right, but we got it. All right, got it. All right. Clerks Praxis. Got it. All right, so let's get ready to go on a journey. Before we get into it, I just want to preference everything. You got to understand, y'all got to pay attention to this. This is a study, okay? This is not nothing you can be in the chat room talking to somebody, going back and forth. You need to pay attention to what I'm going to be saying to you, because you're gonna have to take this as a foundation for all of your studies to have to do what we're doing. You know, a lot of people, they attack me and say, you know, that secure party is bullshit, or I'm defrauding people and things like that. So that, you know, and I can understand the attack. Sometimes I do have to answer the attack. I have to go out and say, okay, I'm going to take that challenge, because I'm more than up to the challenge. I don't think you individuals out there, y'all ready for me. You may think that you are, but I don't think that you are. So I've conducted thousands of hours into what I'm talking about right here, and I'm very confident in what I'm talking about. And I'm going to share it with the people, and I'm going to let the people be the ultimate arbiter of the information that I'm giving to everyone, not you. Fuck all you niggas. Y'all can suck a dick and die, all right? But I'm gonna give this information to the people, and they can make the decision on whether or not what I'm saying, if I'm getting over on the people, or whether I'm giving something them of some sort of value, okay? So with that being said, Let's get to it. The clerk's praxis, all right. See if I can make it bigger. All right, so in the beginning, you'll see, and I love this copy of it. This is the copy I actually had in jail. This is actually the same copy. The practice and jurisdiction of the Court of Admiralty in 3 parts. Part 1 is an historical examination of the civil jurisdiction of the Court of Admiralty. I want you to pay attention that it is a civil jurisdiction. This means it has to do with money. This is the basis of your debtor's prison, and it's also the basis of everything that we're being discussed. And it's actually civil. When they call something criminal, a penal action is actually civil in nature. And I'm going to pause real quick. We're going to talk about a penal action. I have to pause. Write this word down. Write this word down. Uh-oh, let me see. I think it's over here. Yeah, okay. Yeah, right here. Let's write this word down. Okay, this is called a penal action. A penal is a very important word for you to know. Very important word for you to know. This is also for all you attorneys out there who think that there is a difference between criminal jurisdiction and civil jurisdiction. So I think it's listed under action. So let's go in Black's Law Dictionary. And then we're going to go to the word action. What is an action? What is an action? Action is 954 times in here. Damn, there's a lot of action. The word action, boy, it's a lot of actions. Let's see if I can move it along faster. Action. Okay, got act. Which y'all need to study that word too, because you got so many people talking about act. I wonder how many of y'all actually just looked up the word. All right, so you got action, actio criminis, actio. I'll see how many different words there are. Action. Is this it? Act. Let's act. This is it right here. Where's the damn word? The action of account. I passed it up. Action and equity. Action agenda. Actionable. Yeah, this is right here. This is it. We're coming up on it. Maritime law. Action. Penal action. There it is right here. Penal action. All right. All right, so right here. There's a word I want y'all to look at. Penal action. Pay attention. A criminal prosecution. And then it directs you to Corpus Juris Secundii, which is a legal encyclopedia. That's what CGS is. Y'all can go and you can get... That's where you want to go if you want to study and become an expert on the subject of penal actions. You start right there. That's your starting point because it's going to lead you into the case law. And the case law, you can start shepherdizing that law, see if it's still good law. But that's how you do your research. You look up the word. It will direct you to a legal encyclopedia or some sort of reference material. Go to that reference material that's going to direct you to case law, and then you read the case law and allow the judges to instruct you and educate you on the particular subject. So right here you have 18 Corpus Juris Secundii actions. And then we have sense 2. Okay, a civil proceeding. Notice that it's a criminal prosecution, but it's civil in nature. It's civil in nature. a civil proceeding in which either the state or a common informer sues to recover a penalty from a defendant who has violated a statute. That's what's happening to you. You're being sued and you're being penalized. This is why there's a penal sum on the GSA bonds. You start putting all this stuff together, you'll see why all of this stuff connects like a puzzle. All right? You're being sued. It's a criminal proceeding. Looks just like a regular proceeding. Look at it. It says, although civil in nature, a penal action resembles a criminal proceeding because the result of a successful action is a monetary penalty intended like a fine to punish the defendant. All right? This is what a tax is, too. A tax is a monetary penalty. You got to look up the definition of tax and see how taxes can be paid in ways other than with money. And that's what they do when they put you in jail. You can pay taxes with labor. Let's look at the expert commentary and what they say. It says, at one time, it was a frequent practice when it was desired to repress some type of conduct thought to be harmful to do so by the machinery of the civil rather than the criminal law. This is what we're about to read when we read Clerks' Praxis. This is the Clerks' Praxis is the machinery of the civil law. When you would kill somebody or injure someone, you would punish through the civil rather than the criminal. I want y'all to pay attention to this because they try to act like there's a distinction between the two as this never existed. Back in the day, if you did something wrong, you had to pay for it. If you couldn't pay for it with money or gold, they put your ass in jail. Oh, that right there costs you about, 20 silver pieces. Can you pay for that? Okay, lock his ass up. That's how it went, and that's how it's going today. But they're hiding it from you because there is no money. There's no money to pay for things with. So they're creating money through the creation of liens. They're not telling you what's going on today. And there's a reason for it. And it's a very good reason for it. I understand why they're not doing it, because a lot of people are not responsible. But I want you to pay attention that when they used to want to repress some sort of conduct back in history, they didn't use a criminal action. They used a civil action against you. This is the history of debtors' prisons. What they call debtors' prisons. Is everybody following me? Okay, so this means, the means so chosen was called a penal action as being brought for the recovery of a penalty. And it might be brought according to the wording of the particular statute creating the penal action, either by the attorney general on behalf of the state. Ain't that what they doing today? Ain't the attorney general on behalf of the state? Ain't he the one that's prosecuting you on behalf of the state? The attorney general on behalf of the state, or by a common informer. There's a person out there calling himself the common informer too, who wrote a paper on persons. If you're out there watching me, check. Yes, I read your paper. And I don't agree with everything you fucking saying, especially when it comes to secure party. You good, but you ain't that damn good. Or by a common informer on his own account. A common informer was anyone who should first sue the offender for the penalty. Penal actions are still possible in a few cases. This is where they get you right here. Penal actions are still possible in a few cases. No, it's possible in a lot of damn cases. What you mean in a few cases? And this is for your attorneys. This last part of it is predicate is for you. And their existence renders invalid several suggested distinctions between civil wrongs and crimes. All right? So right there, if you're an attorney out there and you're talking about there's a difference between criminal and civil, this man just told you that you're full of shit. Now, either I don't understand what I'm reading or you don't fucking understand what's being said right here. So right here, 4, in penal actions, unless the statute expressly authorizes private persons to act as informers, the state alone can sue and recover the penalty. And yet there is full authority for ranking such suits by it as a merely civil proceeding. All right? So right here, I want you, and you're going to see people like Byron Beers, which we're going to look at some of his stuff. He talks about penal actions. You got some other gurus. I'm not the first guru to talk about penal action or refer this to penal actions. All right? but I want to bring your attention to the fact that you can be in a criminal prosecution and it look criminal, but it's actually civil in nature. Somebody's after some money and they ain't letting you. So when they come in there and you come in there and you drop your birth certificate over the well of the court, or you're giving them some sort of bond or something like that, and they try to act like you don't know what's going on, that's a front. This is why you got to learn how to corner them with questions. Where the donations at? Let's get the likes up and let's get some donations going. Donations make me go good, you know, $5, you know, whatever, you know, and $2, I don't care. You know what I'm saying? Just put something out there, you know what I'm saying? But let's get the likes up. I really want the likes. All right, let's get those likes up. All right, let's get it up to 100. It's at 95 right now. Let's get there's 156 people watching. So right there, we got a penal action. All right. You need to write that word down and you need to study it. You need to study it, study it, study it. Penal actions is what was called admiralty. This is where the admiralty is tied in. So when we get through studying Clerks Praxis, I want you to compare what we're studying with the Clerks Praxis to these penal actions. They don't call it these today. I'm gonna give you an example of what I'm talking about. If you go to the official code of Georgia annotated, I don't know about your state, but this is where I learned all this stuff in Georgia. So if you go to the official code of Georgia annotated, let's see, let me go on Justia. You can look at how the codes are. All right, so right here you see, this is it. It's called debtor and creditor law. That's it right there. That's what they call it. They don't call it admiralty. They call it debtor creditor law. And when you got Title 15, Title 17 is criminal procedure, crimes and offenses. And then right after that, they have debtor and creditor law. When you start looking at this, you're going to see these two right here go together. But you don't know that. Right here, the first thing tells you the general debtor and creditor relations, general provisions, creation of a relationship. Pay attention. Whenever one person, by contract or by law, is liable and bound to pay another an amount of money, certain or uncertain, the relation of debtor and creditor exists between them. So if you owe child support, there's a debtor and creditor relationship. If you owe restitution, there's a debtor and creditor relationship. If you owe some sort of fine, there's a debtor and creditor relationship. What the fuck are these attorneys out here talking about? If you got a debtor and creditor relationship, you fall under you are a debt collector, and you fall under the Fair Debt Collection Practices Act. Child support is a debt collection. Child support services is a debt collector. I read this in case law. I'm not just saying that. I've read this. And I told, as a matter of fact, I was on child support. I paid it all off, but it was years ago. But I called into the people and I accused them, and I said, y'all debt collectors. He got quiet because my ex-wife had moved to another state. She moved without permission, and they tried to put me on child. I said, I don't got no contract with you. How y'all putting me on child support up here? I said, I want a verification of debt. I want y'all authority. They've got nervous as hell. Y'all need to start calling these people out. Child support services is a debt collector. And they use coercive tactics like canceling your driver's license and things like that to get their money. That's the only leverage they got on you. They use coercive tactics. So this is a principle of law. Don't pay attention to the fact that this is OCGA in Georgia. This is a principle of law. They just what they do is they put principles and statutes. It applies you just can't refer. You can use that phrase in there whenever anybody owes anybody other people money. There's a debtor and credit relationship. You just can't refer to OCGA, this OCGA 1821. Now you can go in your statute and find it, because I guarantee you they got it codified somewhere in your statutes in your state too. You're going to have to look and find it. So we understand that we got penal actions is a criminal proceeding that's civil in nature. When we're talking about civil, we're talking about money. Some sort of pecuniary interest in property. All right, so let's go to the clerk's praxis. So, the Clerk's Praxis by John Hall. It's an old book, but he was an authority on the admiralty. This book is in 3 parts. The first part, as you can see, is an historical examination of the civil jurisdiction of the Court of Admiralty. Let me see if I can blow this up a little bit more. All right. The second one is a translation of the Clerk's Praxis with notes of the jurisdiction and practice of the district courts. That right there is the statutes. Okay, so the first one is the history. The second part is the statutes. The third part is the case law. A collection of precedents. That's how they got it set up. Very, very interesting to see how they used to do it a long time ago. I appreciate that. UQ Ant, appreciate that. Mark Flores, appreciate that. Appreciate that. Dr. Mink, appreciate that. Daniel Cardenas, appreciate y'all, bro. Appreciate the love. Appreciate the love. I appreciate that. Thank you. All right. So, John E. Hall, Esquire, is the person who wrote this. So let's get to it. Let's get into it. All right. We're gonna get in the history of this. So the history is very, very interesting, especially if you are a Moor. Because you know the word admiralty is a Moorish term. It's a Moorish term. And they're going to tell you that right in here. Part 1, historical essay of the civil jurisdiction of the admiralty. Part 1, historical essay of the civil jurisdiction of the admiralty. So we can see very clearly that admiralty is civil. Remember, when we go into court, we're asking them a question. Hey, look, man, the Constitution for the United States only grants us to 2 criminal jurisdictions. One is under the common law. You got a common law criminal jurisdiction, and the other constitutes a condition of contract under criminal aspects of a colorable admiralty jurisdiction. Okay, it requires a contract. You're going to see that admiralty is based off of contracts. So there, you have to be some sort of contract to come under this jurisdiction, which is what they have done to pull you into the democracy. The Social Security contract, the driver's license contract, and a myriad of other contracts that you enter into on a daily basis. Whether implied or express, they're bringing you within their jurisdiction under their umbrella. That is why it is possible to come out of it. This is what status correction is all about. Identifying all the minimum contacts that tether you to the system and then severing those contacts. That's why the first thing you got to do is stop using the Social Security number. And you're going to put in place some sort of corporate ID, like a 405 number or a 98 number. So, let's get to it. And a lot of y'all coming late, start having y'all ass on time to class. 2:30. Historical essay of the civil jurisdiction of the admiralty. All right, so let's get in there. The origin and antiquity of the title admiral has exercised the research and divided the opinions of many profound writers upon this subject. Such an officer is to be found in most kingdoms that border upon the sea, and it is said that Philip of France was the first who conferred the title in civilized Europe. This was in 1284 or 1286, but the same writer finds the name of this officer occurring once in the history of France, so early as the year 558. So they see this word admiralty goes all the way back to 558. By Duquesne, we are informed that the Sicilians, who are Italians mixed with blacks when the Moors invaded, were the first, and the Genoese the next, who gave the denomination of admiral to the commanders of their naval armaments, and that it was derived from the Saracen or Arabic word emir or emir. We know what a Saracen is. An Arabic person. A Saracen or Arabic word, amir or emir, a general name for any commanding officer. According to some writers, the first admiral who is recorded in English history was in the reign of Edward I in 1297. Remember, Edward I is the one who brought in the statute merchant. Appreciate that, Andrew, 4580. And I'm reading all this, y'all, because I want people to see why I stick to my guns with Secure Party. I think some people are under the impression I'm just selling some information that somebody else gave me. That's not what it is, bro. If you out there and you thinking that about me, you don't know me. You don't know shit about me, man. It's really insulting to me. It just shows me that you are not the kind of person that does your due diligence. I didn't create any of this. That's why I give people their credit, because I didn't create this. But if it was not for so many people who came before me and researched this, I wouldn't have even known where to look. Why would I not give these people their credit? And why would I take credit for something that I didn't do? That's what you have a lot of these other so-called gurus out here doing. They want you worshiping and following them. They didn't create none of this shit. Somebody taught them. But I thank Gene Keating for this, but I took the initiative to actually go and read and study it. Hell, I didn't have nothing else to do. I was in solitary confinement. Shit. I made a promise to myself I was going to make them people pay for putting me in solitary confinement. I said, if y'all going to put me in solitary confinement and give me all this time, you're going to pay for that shit, because you're going to create a monster when I come out. You created a fucking monster. You give me all that free time to read books, and you don't think I'm going to do? You think I'm one of these people that's going in there and sit up there and play Texas Hold'em and watch the goddamn football game every day? And then you put me in solitary confinement with law books? I will fix your login. I will. I got everybody. Trust me. We are on everybody's login. Thank you, King Valas. Valius. Forgive me. And thank you, Sharon W. I appreciate you, baby. Thank you, King Valius. Appreciate the 50 bones, dog. I love that. Appreciate that. Appreciate the generosity, sir. All right, let's get on. Let's keep going with that. All right, so we on the historical. If you just joined us, right now we are researching the history of the Admiralty. So by Duquesne, we are informed that the Sicilians were the first and the Genoese the next who gave the denomination of admiral to the commanders of their naval armaments, and that it was derived from the Saracen or Arabic word emir or emir, a general name for any commanding officer. According to some writers, the first admiral who is recorded in English history was in the reign of Edward I in 1297. And the first title of Admiral of England, which was expressly conferred upon a subject, was given by patent from Richard II in 1387 to the Earl of Arundel and Surrey. But Spelman, in his opinion, that title was first used in the reign of Henry III. And these are guys who are actually experts. They are very back in his day, you know, some of his contemporaries. Because it does not occur in the laws of Oleron. Somebody emailed me the laws of Oleron. I don't know who that was. I think it was somebody from, I don't want to say the Illuminati or something like that, but I did get the message. And I have not studied the laws of Oleron yet. It was the weirdest thing that ever happened to me. But I'm going to share it with all of you. I haven't even read it yet. I haven't gotten a chance to study it, but I am. But y'all need to check out the laws of Oleron. Enacted in 1266. Nor is mentioned by Bracton, who wrote about that time, and in a charter of 8th Henry, which granted the office of Richard de Lacy, the title is not used. But in the 56th year of the same reign, the historians used the appellation, and it is likewise found in charters. The title Admiralis Angeli was not frequent until the reign of Henry IV, when the title was given to the king's brother. These particulars are not without interest to many readers, but As it is neither within our purpose nor ability to investigate them fully, we leave the subject to the antiquarian and the lexicographer and hasten to another which is more important and less enveloped in mystery. All right, so that's a nice little tidbit of information he's saying, but we really can't explore this the way that we want to. Let's get to what we can talk about. The jurisdiction of the civil or instant court of admiralty, as it is at the present understood, appears to be of a strangely anomalous kind. Mariner's wages. I want you to pay attention to this mariner's wages, because in the Constitution, it talks about the compensation of the government. These mariner's wages, because they're going to use a lot of admiralty terms. You need to write. I hope you got a pen and pencil and write this down. I want you to look up every single fucking word you do not know the definition of. If you're really interested in being an expert in this subject, you're not going to pass over any word you do not know. As a matter of fact, we're going to take some time and we're going to look up the words. That's why it's going to take more than 3 days to go through this, because you don't know what these words mean. And so we're going to take time to look them up. So mariner's wages, except where the contract is under seal. We got to write contract under seal. What is that? Contract under seal is a deed. You will see that they file some of your court paperwork under seal and you think that they're trying to hide it. But actually it's a deed, especially when you violated probation. Violation of probation is like a foreclosure. We're going to get to all of this. I'm trying to tell you. I'm just touching you up right now. Just hitting you with a little two-piece here and there and everything, and we're going to verify all of this right now. But I just want y'all to understand what we're talking about. So we got mariner's wages, except where the contract is under seal or is made in an unusual manner. Bottomry, I want you to write that word down. In certain cases only and under many restrictions. And salvage, write that word down. When the property is shipwrecked, is not cast ashore, appear to be the only subjects which is now considered to be in the legitimate cognizance. I want you to write down the word cognizance. Cognizance is a synonym for jurisdiction. Sometimes you will see them use the word jurisdiction. Sometimes you will see them use the word cognizance. You should understand that both of these words are interchangeable. They didn't use the word jurisdiction back then. So right here, by the publication of Dr. Robinson's reports, and I haven't been able to locate a copy of Dr. Robinson's reports, and maybe for somebody else out there they can find it. But these, reports are, usually a compilation of case law or something like that. There are many different kinds. I'm not saying that you have to have that, but it would be interesting to find it. By Dr. Robinson's reports, we have been, however, for the first time informed, for in the common law books, there is no trace of it to be found, that the Court of Admiralty of England entertains suits for the mere possession of these vessels, though it never interferes with the title in controversy. We also have to mention that the Admiralty has an ancient and long recognized jurisdiction to decide between the part owners of a ship or vessel who differ among themselves about the policy or advantage of sending her on a particular voyage. This particular voyage, now I want you to think about, what is the voyage? Right now, the United States is on a voyage. They went into bankruptcy, all right? They borrowed money from the Federal Reserve. They $31 trillion in debt. They shipwrecked. Where are they on a voyage to? You're going to start, as you start to read this and you start to read the dictionary, you're going to start to see, I see what's going on now. You're going to see how they're hiding what they're doing through the use of words. The names have been changed, but the players are the same. This is the game. I'm trying to remove the veil for you to be able to see clearly what is going on, because they've been hoodwinking you and deceiving you for so long all over the country. They got y'all taking plea agreements like running through fucking McDonald's. So let's keep going. The Court of Admiralty. On considering the present state of the civil jurisdiction of the Court of Admiralty and tracing back its history to ancient times, we were induced to believe that those different subjects of which it now has the acknowledged cognizance were the venerable remains of a much more extensive jurisdiction which it was long permitted to exercise, notwithstanding the restrictive statutes of 13 and 15 of Richard II. So back in the day, the Admiralty had a very, very much broader, extensive jurisdiction, as in his time, he says, it's been restrained. They have extended that jurisdiction again. They started extending it after 1913. This is why you have to see the history. This is not the first time this has happened. This is happening in modern times. Sometimes the common law will dominate. Other times it might dominate for 50 years, 60 years. Next thing you know, Admiralty come in, they dominate for a little while. Next thing you know, common law come back. They've been switching back and forth for a long time. This is not the first time this has happened. This opinion was confirmed by perusal of the present work. As the Court of Admiralty is constituted at the present, the greatest part of the proceedings in civil cases is in rem. The word in rem is against a thing. As a matter of fact, we're going to pause and we're going to look up this word. In rem. You need to know what in personam is and in rem. Write both of these words down. They are very important. So let's look at these words real quick. Peace, gods. Peace, peace, peace. All y'all people coming late to class. Y'all walking in the classroom late and shit saying, what's up, Yusef? You supposed to walk in the classroom and keep your head down. You don't walk in the damn lecture hall talking about what's up. Late to class. All right, so let's go up here. In rem. Right here, in rem. Right here. In rem, Latin, it means against a thing. The word thing is another word you need to look up too. Thing is a legal term. Thing. But it means against. In rem means against a thing. In rem means against a thing. And personam means against a person. We're going to look at both of them. So in rem, against a thing. Involving or determining the status of a thing. Whoa. And therefore the rights of persons generally with respect to that thing. Slaves are things. Slaves are things. Slaves are things. Let me say it one more time. When you're in debt to someone, you are a slave. I don't think nobody going to argue me with that. Thank you, Timothy Reiser. All right. So let's keep going. Let's read it again. Involving and determining the status of a thing and therefore the rights of persons generally with respect to that thing. Also termed archaically impersonal. See actions in rem under action. An action in rem is one in which the judgment of the court determines the title to property and the rights of the parties, not merely as between themselves, but also against all persons at any time dealing with them or with the property on which the court had adjudicated. Now, we're going to see that in rem there's going to be a lot of discussion in the clerk's praxis of actions in rem and actions in personam. You're going to see a lot of discussion on that. So you need to acquaint yourself with these words, in personam and in rem. Let's get in personam real quick. Right there, in personam. In personam, against a person. Against a person. Involving and determining the personal rights and obligations of the parties of a legal action brought against a person rather than property. An action is said to be in personam when its object is to determine the rights and interests of the parties themselves in the subject matter of the action. However, the action may arise, and the effect of the judgment in such an action is merely to bind the parties to it. A normal action brought by one person against another for breach of contract is a common example of an action in personam. So breach of contract is an action in personam. You just learned something, okay? Determine the rights of the parties. So I want you to write these words down on a flashcard. I want you to put the word on one side, and I want you to put the definition on the other. And every morning when you wake up, I want you to just read it. I don't want you to strain your brain trying to memorize it. Allow your brain to gradually allow the definition of the word to seep into your psyche. That is through repetition. These motherfucking evil-ass people, they doing it to you with this hip-hop music. Y'all letting that shit seep in your brain every damn day. It's the same concept that I'm talking about. Just take a little time to look at these words every day, and it will seep in your brain the same way these damn rap songs do, without you having to struggle to try to memorize it. Repetition is the key to learning. All right, let's get back to the clerk's praxis. It can't take too long to go into that, but I read the definitions because I want you, the reason I read the definitions because I want you to say you read the definition. See, when you leave my live stream, you can't say you didn't read the definition. You read the motherfucking definition. You read it. All right, so let's go. So once again, as the Court of Admiralty is constituted at present, the greatest part of its proceedings in civil cases is in rem against a thing. Indeed, it was not long ago held that it had no jurisdiction in personam, and that question was agitated so late as the year of 1781 in the great case of Lecoq versus Eden. If then, in the reign of Elizabeth, when our author wrote, the jurisdiction of the Court of Admiralty had been limited as it is at present, his rules of practice would have been particularly directed to the special cases of which it had cognizance, and particularly to proceedings in rem. Whereas the modern subjects of Admiralty jurisdiction, bottomry, write it down, salvage, write it down, and mariners' wages, write it down, were not even mentioned. And only a single chapter or title, the 41st, relates to those proceedings which may properly be said to be in rem. For we cannot call by that name an attachment of property. I want you to write down the word attachment. I want you to write down that as a word that you need to be familiar with, like an attachment lien or writ of attachment. A writ of attachment is a warrant for an arrest. Let me pause right here, and we're going to look at something real quick. A writ of attachment is a warrant for an arrest. And I'm going to give you an example of how you can be reading something and not know what they're talking about. So we're going to go to OCGA 1711-4. Now, if y'all notice that I just posted a video on my channel of a prosecutor refusing to drop charges on someone, even though a police officer was caught committing perjury and the judge went off on her. Why are they so recalcitrant? Why they have so much refusal to drop charges? Are they just evil? Are they just being evil, or is it something else? Is it something else? Are they liable? Have they got some sort of liability, and if they drop the charges, the liability is on them? Well, let's see. Let's see. Let's see. We're going, and this is what I have to do. I have to use they shit. Because you don't use they shit, they'll say, what the fuck are you talking about? All right, so let's look at it. Imposition of cost. I want you to write this word down, cost. Cost and cost, C-O-S-T-S. That's not a plural word. That's actually a word, cost. And jail fees upon prosecutor or complainant. The prosecutor's name shall be endorsed on every indictment, and he shall be compelled to pay all costs and jail fees upon the acquittal or discharge of the person accused. When? Okay, so now we got some insight. That's why the motherfucker don't want to drop the charges. Because the cost is going to fall upon his head. And this is the cost that we're asking when we come into court and we ask the judge, Your Honor, I request the Honorable Judge direct the prosecutor to provide the assessment for the charges, along with a certified audit trail of all transactions, including voucher, as well as all disbursement documents and receipts. Do you see what I'm asking? I want the accounting of what's going on behind the scene, because you're operating under some sort of presumption that I'm not interested in that, and I'm here to rebut that presumption, sir. I'm interested in anything that have to do with the restriction of my liberty. I want to know about it. So, what will he be liable for? One, if the grand jury, by its foreman on returning to no bill, expresses as his opinion that the prosecution was unfounded or malicious prosecution. Two, a jury on the trial of the prosecution finds it to be malicious. Or three, the prosecution is abandoned before trial. When it is thus abandoned, the officer who issued the warrant shall enter a judgment against the prosecutor for all costs and enforce it by execution in the name of the state by an attachment for contempt. What is an attachment for contempt? Let's go to our dictionary. They're going to enforce it through an attachment for contempt? Let's look at that. What is that? What the hell is that? What are they talking about? Now you begin to know. Now, how did I find this out? I found this out by reading creditors and their bonds. This is what led me to this. I'm like, oh, that's why they don't, because I used to wonder, why these motherfuckers don't want to drop the charges? They don't be having no witness, no evidence, nothing. They still hold your ass in jail, don't want to drop the charges. You have to keep going back and forth in court for 2, 3, 4 motherfucking years. And you're like, well, what the fuck? Why won't they drop this bullshit? That's why. Let's look at it real quick. No, I don't need to talk to Trump. I need to talk to Joe Biden, walking around acting like he crazy and shit because they on his ass. I'm going to talk to Trump. Let's look at what an attachment is. Let's look at it. Okay, this is what attachment is. A seizing of personal property to secure a judgment or to be sold as satisfaction of a judgment. That's sense one. Attachment of wages. We know what that is. But let's get down here. Let's look at, here it is, number 2. What is an attachment? The arrest of a person who is either in contempt. Remember they said an attachment for contempt? So they said attachment, you remember what they're saying right here? You're going to do what? Attachment for contempt? Attachment for contempt? What is an attachment for contempt? What they trying to do with the prosecutor? They trying to do what to him? They trying to arrest his ass. The arrest of a person who is either in contempt of court or is to be held as security for the payment of a judgment. Oh, doesn't that sound like the statute merchant? Doesn't that sound like the statute merchant? You got a judgment against you and they're going to hold you for what? As security for the payment of a judgment? Why is, okay, so this ain't all fantasy what we talking about. See, we start running through these statutes. The reason I knew I could do this is because I know these people ain't smart enough just to create something out of thin air. Everything that they got is built off of hundreds of years of studying law. That's what they got today. They didn't just make this shit up and pull this shit out their ass today. They ain't that fucking smart. So right here, you can see the arrest of a person who's either in contempt of court, who's to be held as security for the payment of a judgment. And then sense 3, a writ ordering legal seizure of property, especially to satisfy a creditor's claim or of a person. Also termed writ of attachment. The creation of a security interest in property, occurring when the debtor agrees to the security, receives value from the security property, and obtains rights in the collateral. We talk about an attachment. That's what an attachment is, man. A very important word. That's why if you want to start studying this in your statutes, you need to be looking anything in your statutes talking about attachments. I guarantee you're going to start to see something. Your eyes are going to be open. You're going to start to see something with a writ of attachment, attachment liens. Start looking at all of that stuff. They're using different terminology today, but you got to study the history and bring it up to today and say, oh, this is the same bullshit they've been doing. They're trying to act like we ain't got debtors' prisons no more. We got debtors' prisons today. They don't want you to know that because they have to create money through debt now. So they have to put liens against property. So that's why they need your social security number so they can put a lien against your estate. They don't have to go in the account. A lot of people say they went in your account. They're not going in your account. They're putting a lien against your account. That's all they need to do. Debt is the evidence of debt is used as money today. So once they create an evidence of a debt with a security interest in property and then arrest your ass and hold you as a security for the repayment of the debt and make you go to jail and get a goddamn job, they can discount that paper and sell it on the stock market. This is the same shit they were doing in slavery. They were selling the slaves through debt, man. Peonage. Indentured servitude. The same shit. They didn't make this shit up. They doing the same shit. Slavery didn't go away. The 13th Amendment didn't remove slavery. It put it in the prison system. So you think they created some new kind of way to sell slaves? No, they didn't. They just modernized it. Do y'all understand what I'm saying? Is anybody, let me put a camera on me. Is anybody confused on what I'm saying? Are you confused? Do I sound like a crazy person? I could be wrong. Maybe I am misinterpreting what I'm reading, but I consider myself to be a very intelligent person, okay? I studied this for a long time. I've watched, they put things in movies all the time. Go watch 12 Years a Slave and pay very attention when that guy was begging not to be sold. He said, I already sold your debt to the other plantation. You have to pay. These people, they so arrogant, they will tell you what they're doing to you because they don't think you smart enough to see it. They think they got you so drugged up, so preoccupied with busting nuts and smoking weed and drinking liquor and having fun that you will never, ever see this right in front of your face. They put it right in front of your face. Let Me In was good, wasn't it? That's a vampire movie. Has some good principles in there. You have to be invited in. Let Me In was a serious movie. Let's get back. All right, so let's go back. Whereas the modern subjects of admiralty jurisdiction, bottomry, salvage, and mariner's wages are not even mentioned, and only a single chapter or title, the 41st, relates to those proceedings which may properly be said to be in rem, for we cannot call by the name an attachment of property for the mere purpose of compelling the appearance of the defendant, on which the plaintiff does not claim any right or ownership or lien. All right, they claim, okay, so they arrest you. This is what they do. They arrest you, and then they compel your appearance, and they have some sort of right of ownership or lien. They're doing that. They arrest you first. In the first instance, you get arrested, and they make you sign a bond. Do they have some sort of right of ownership or lien? They do if you have a social security number and you attach to the national debt. as is the case in a suit of a bottomry bond, or you write down bottomry bond, or for seaman's wages, write that down. But it seems from the content, and this is what I want you to do too. If you are in federal prison, you really need to be studying this, because you need to get a copy of you need to get your docket sheet and get you need to get your discovery, but get a certified copy of your docket sheet from the clerk. And then as you read this, you need to pay attention to it and look and see how they put commercial bonds in there. And then you're going to start seeing all this stuff. So you ain't been paying attention to it because you just been looking at the indictment. That's all the fuck you looking at is the indictment. No, get your docket sheet and start looking and start studying this and start comparing and contrasting and juxtaposing it. And then you're going to wake the fuck up. See, my job is I won't be here long. I'm here to get the next generation ready so you can catapult off something I give you and you can take it higher. Because I'm just one man. But I know the creator of the boundless universe put me in place to stop this bullshit of they just locking us up and taking away our freedoms and breaking up our families and breaking up our marriages and doing things like that. That shit got to stop. And making it seem like it's our fault or that we bad people. They're going to tell you in here that admiralty don't have nothing to do it's the law of the sea, but it don't have nothing to do with the locale. This is another reason why I want to read this, because there's this misconception that admiralty is just the law of the sea. Who the fuck goes out on the sea and makes a contract at sea? That's what they're going to talk about in here. Indeed, it evidently appears that the greater number of suits which the admiralty then entertained were actions of debt founded upon contract, which were enforced in the first instance by the arrest of the debtor if he was present, and by attachment of his property in order to compel his appearance if he was absent. Don't that sound like what they're doing? At first they arrest you. It's a contract. Let me repeat what we say when we go into the courtroom. Your Honor, the Constitution only gives this court two criminal jurisdictions. One is under the common law. The other constitutes a condition of contract under criminal aspects of a colorable admiralty jurisdiction. Please, sir, tell myself and this court under which two jurisdictions you're trying this criminal action. Because you're trying to put a lien against something. This is why you're doing the secured party process. First in line, first in time. They're trying to put a lien against property you already got a lien against. Now you understand why don't none of these UCC filing offices want to file your UCC-1, even though the only name on there is your name. Why the fuck do they care if you file a UCC-1? It's just your all caps name and your name on the motherfucker. What is wrong with you? Why you don't like it? Why they got a problem with we paying you? You public servants. Why the fuck do you care? If this don't have no basis in law and fact, why the fuck do you care if I file a UCC-1? Let me read that again. Indeed, it evidently appears that the greatest number of suits which the admiralty then entertained were actions of debt founded upon contract, which were enforced in the first instance by the arrest of the debtor if he was present, and by attachment of his property in order to compel his appearance if he was absent. That's why when y'all go in there and challenge jurisdiction, they will fucking hold you in jail to compel your appearance because you're refusing to appear. They entertain predatory suits. Write that word down, predatory suits. in which they decided on the title to property as well as possessory suits. Write that down. For the mere possession of property. This is when you get into foreclosure. Title and possession. No trace whatever appears of such a limited jurisdiction of the Admiralty possesses at the present day. And it is remarkable that during the long reign of Queen Elizabeth, 44 years, no prohibition appears to have been issued against the Admiralty Court, except 2 or 3, which were mentioned by Lord Coke in the 4th instance, but which we do not find elsewhere reported, and which, if his reports be correct, were in violation of the agreement that will hereinafter be mentioned. The Admiralty jurisdiction then, as far as we are now able to trace it, extended to all cases of freight, charter parties, bottomry, mariners' wages, debts due to material men. That right there is important. Debts due to material men. Who are the material men? Who are the debts due to them? Debts due to material men for the building and repairing of ships, and generally to what was then considered as maritime contracts. Maritime contracts are secret liens, like a maritime lien. It extended also the contracts made abroad, because they were to be decided according to the civil law, which was and is still the law of admiralty. Civil law was and still the law of admiralty. They just call it the civil law. Which was and is still the law of admiralty. Do I need to read that again? It extended also to contracts made abroad, because those were to be decided according to the civil law, which was and is still the law of admiralty. This jurisdiction was secured to that court by an agreement which was signed in the 17th year of Elizabeth by all the common law judges in order to put an end to the disputes which their jealousy had excited and perpetually kept alive. Now, you're going to see this war against the common law courts and the admiralty courts. There's a reason that they use an admiralty right now, because there isn't any money. There's a reason for it. They had to switch to contracts because there's no gold. They had to switch to colorable contracts because couldn't have a real contract unless there was something of substance to make it, a real contract. This is why Howard Freeman was so important to study. You should read anything Howard Freeman put out. Anything Howard Freeman put out, read it. He was on point just like me. But those articles in the subsequent reigns were not executed with good faith, any more than similar ones which were as solemnly agreed to in the 8th year of Charles I. The judges evaded them, and this is what the common law judges did. They agreed to this jurisdiction with these admiralty courts, but they never honored it. And it says the judges evaded them by subterfuges which were unworthy of the dignity of the bench, and did not observe them longer than they were constrained by the might of royal authority. This is something you need to take into consideration when you're dealing with these judges, and they be dishonorable. They've always been dishonorable when they were supposed to do something. So useful, however, were they considered to be in trade and commerce, that the Republican Parliament enacted them in substance by an ordinance of the 12th of April in 1648. But at the Restoration, that ordinance ceased to be enforced, and the common law judges began again to annoy the admiralty courts with prohibitions as they had formerly done. They did not indeed venture to deprive them of all their jurisdiction. They left them the cognizance of those cases of bottomry and mariners' wages which they entertain at present, but declared that they allow it from mere indulgence and from the necessity of the thing, on the same ground as prohibition was denied in the case of mariners' wages so early as the 8th of James I. It is certain that the Court of Admiralty, in its origin, had and entertained a jurisdiction coextensive with that of maritime courts throughout Europe. Those courts were established for the protection of maritime commerce, to which the feudal judicatures of those times were entirely inadequate. We find them in the Middle Ages established in all the maritime countries of Christendom, and some under the name of admiralty and others under the consular courts. Consular courts. The consulate. It tripped me out when I was down in Miami, and I was in jail in Miami in the Fed, and I was helping a guy. He got arrested. He had got arrested on a boat. He was on a cruise ship. Now, the cruise ship was not an American cruise ship. It was a foreign cruise ship. and it was coming from a foreign jurisdiction. The United States didn't have jurisdiction. On the cruise ship, the gentleman, him and his boy, he worked on the cruise ship, but he was on his break. He was off, and him and his boy, they got with two, and I think this is why they don't allow a lot of, if you notice, if you go on a cruise, a lot of the people who work on there can't interact with the passengers. But during this time, they could. So they found two girls, two passengers, took them back to their cabin, got them drunk. One of the guys took one in the bathroom and knocked her down. The other, he didn't have sex with her, but he had her doing undressing and taking all kind of pictures of her and things like that. After the girls recovered, and after they wasn't drunk no more, they went to the captain. The captain came, arrested them, did an investigation, saw that they didn't do anything, let them go. They poured it in the Bahamas. That happened in the Bahamas. And then when they came from the Bahamas and poured it in Miami, the United States didn't play that shit. The United States arrested their ass. The United States gonna lock your ass up. They don't give a fuck. It's like, fuck it, lock their ass up. So now I want to bring your attention that the ship was not an American ship. None of the people involved in this were U.S. citizens at all. And when the incident happened, they were not under the jurisdiction in the waters of the United States. So I'm looking for, anytime somebody shows me their indictment or their charges, I'm looking for the jurisdictional element. How did the United States get jurisdiction over this case? That's the first thing I look for, because I'm always looking for that interstate commerce clause. So this is interstate commerce. These motherfuckers said that there was American passengers on the boat and they could have been affected. I mean, the prosecutor was reaching for anything. This is what they'll do. Now, it didn't work, and they had to drop the charges and let them go, but I'm just bringing that to your attention and what they will do, okay? That, they'll do things like that. So now, also in his paperwork, though, the reason I'm bringing this up, when I got his discovery, they were asking him, does he want to speak to the consulate? And they tell him, just check no. The consulate is responsible for the commercial activities in the country that you're in. They ask him this in jail. I learned a lot just reading people's paperwork. I read everything when I was in there. I was like a vacuum cleaner because I was looking for evidence of anything, and I had no shortage of people who were bringing me their paperwork to read. This is why I can say about all your attorneys out there, very few of y'all are doing anything. Y'all are doing the same thing. You can talk that shit all you want to. I done looked at all these discoveries. They all look exactly the same. Ain't none of y'all filing any paperwork of evidence in y'all client's evidence file. All y'all doing is taking their money, letting them sit for a little while, coming at them with a plea deal. That's all you're doing. You just high-priced negotiators. That's it. Don't talk shit to me, nothing about the criminal jurisdiction, nigga, because you don't do shit. I looked at hundreds and hundreds of indictments. They all look exactly the fucking same. He's a damn high-priced negotiator. Let's keep going. In the south of Europe, the judges who had cognizance of commercial and maritime causes were denominated consuls. Let me read that again. In the south of Europe, the judges who had cognizance, jurisdiction of commercial and maritime causes were denominated consuls. And the celebrated code by which they were directed was thence called the consulate of the sea. Those consuls were mere civil judges, unconnected with the military or feudal system, but in the north, where feudality most flourished, and where the judiciary power was considered a necessary appendage to military grandeur, the constable, who was at the head of the land armies, and the admiral, who commanded the naval forces, could not consistently, with the dignity of their stations, be without a portion of the judicial authority, while every petty baron had a court of their own. This is where jurisdiction, anybody has their own jurisdiction, got a court. Y'all got to understand, it's way more stuff than just judicial courts. They're all kind of fucking courts. When you go back and study all of this, everybody a baron or lord, especially in this, because they copied this from the feudal system. If a person was a feudal lord over something, he had his own courts. He had all his own shit. He had his own court, his own forces. That's what the knights were for. You need to study history. There's a reason these counties have names. There's a reason, and your jurisdiction, why all these counties have names. These are the people. We live in a kind of feudal system today. You don't recognize it. You don't own this property. You pay property taxes. You don't own that property. The constable therefore invested his lieutenants, as the barons did their stewards, with the power of deciding on all matters and differences which arose out of the wars. Okay, so they bestowing upon their stewards and people, giving them the power to be like judges and shit. And the jurisdiction over maritime affairs naturally fell to their share of the admiral. His court was established on the model of the consular courts, and those maritime contracts which were regulated by the Consolato del Mare and the laws of Aliran were the subject matters of their civil jurisdiction. And that's why I keep saying, falling back, I got to go and study this. That's one of the few things I haven't studied yet, the laws of Aliran. There was like years ago when I first started doing this, somebody sent me something, a recording, and it's like infected my computer, and it was just telling me to investigate the laws of Aliran. I don't know if I'm pronouncing it correctly, but it was, I'm glad I'm reading this again because it fell out of my memory, and this just, spurred my memory back on that, and I know that I have to go in and look at this. I got to go look at it. Of this fact, there is a sufficient evidence to be found in the ancient records that are preserved in England in the Black Book of the Admiralty. I don't know what the Black Book of the Admiralty is. I kind of looked for it. I didn't, back then I only had a little access to things. But now I'm just jugging my memory again. The Black Book of Admiralty. Among these is an ancient statute of King Edward I, by which he ordained, with the consent of his barons, that the stewards of their courts should not hold plea of anything concerning merchants or mariners, whether it be at charter parties, and write down charter parties, of vessels, obligations, or other deeds. Listen, man, let me tell you about these contracts under seal and these deeds. And you got to understand, when I was studying this, I was studying all this from the point of view of dealing with prisoners. This is why I say when a lot of people, they come to me and talk about discharging houses and cars and all that, that wasn't really my background. That wasn't really my background. I got kind of thrown into that because that's what everybody wanted. But my view was to help people with this criminal justice system that we're dealing with and exposing what it really is. It ain't nothing a front, but it's just nothing but a front for slavery. That's all it is, just a front for slavery. They never let slavery go. All right, they never let it go. It's still here, but in order, they had to sanitize it. How they sanitized it by making the slaves look like criminals. So y'all won't bitch or fit. You don't mind somebody going in, oh, well, you shouldn't have did that. Hey, you shouldn't have did that. Now you have to do time in prison. You have to do 20 years in prison. All right, go in there in prison and everything. That you did that to yourself. So it's been sanitized now. The only thing they agreed to do is never to use the word slave. They can't call nobody a slave. So they call you an inmate. They call you a taxpayer. They call you words like that. They call you an employee. They got all kind of words they use for you now because the agreement was we can never use the word slave. That's what the 13th Amendment was about, never using that word again. Voluntary servitude is permitted. It's just involuntary servitude is not permitted. Matter of fact, let's pause and let's read that because I had to substantiate what I just said. Let's read that real quick. Let's read the word slavery. Let's read it real quick. Let's see if what I just said is true. Let's just see if what I just said is true. Slavery. A situation in which one person has absolute power over the life, fortune, and liberty of another. Sense 2, the practice of keeping individuals in such a state of bondage or servitude. Slavery was outlawed by the 13th Amendment to the U.S. Constitution. All right, let's see. That's just a general type thing. That's what they said. But let's look at the expert commentary, what the experts say about that. All right, the people who go, the antiquarians and the people who actually do the real research on all this stuff. Let's see what they say about this. All right. Slavery was a big problem for the Constitution makers. Those who profited by it insisted on protecting it. Those who loathed it dreaded even more the prospect that to insist on abolition would mean that the Constitution would die a borning, meaning at its inception. All right, you had the abolitionists and you had the slaveholders. They like, look, we got to come to an agreement on this slave stuff or this Constitution ain't never going to come into existence. So the framers reached a compromise, a compromise of sorts. The words slave and slavery would never be mentioned, but the Constitution would safeguard the peculiar institution from the abolitionists. Do you see what the fuck he just said? The Constitution didn't eliminate slavery. The Constitution protects motherfucking slavery. Peculiar institution is another word for slavery, okay? Do you see this right here, what these people just said? And when you read that, go back and read it again and see, don't you see, like, yeah, that is what it's saying. See, you got to use their books. I learned a long time ago, the reason I started reading case law, because I got tired of hearing all this sovereign citizen bullshit and all this. I said, you got to read the case law, man. You know, because they're going to keep on trying to make it seem like, oh, you got that off the internet. You crazy. Oh, they got this sovereign citizen, this, what they be calling names and shit. That's one of their techniques. Label you, and then the next step is make you look crazy. Label you, then make you look crazy. Put you under a label. All right, let's keep reading. Right now, if you just joined us, we're reading the Clerks Praxis. It's in 3 parts. The first part is the historical essay. The second part is the statutes, and the third part is the case law. Right now, we're reading the history of admiralty. It is extremely interesting. It may take us a couple of days to go through this, and probably 2 days. All right, so I'm not going to get through the entire thing today. How long I've been doing this right now? Hour and 22. Okay, we rolling. All right, we're going to keep rolling. All right, so let's look at it. All right. I want you to pay attention to this word deed is going to keep coming up. Because when I was studying, when I was looking in these court documents, I started noticing that stuff was filed under seal and things like that. And under seal has to do with a deed. You know, when they call you state property, they mean it. They got some sort of deed to your body, to your property. So when you let on probation, probation is still incarceration. So when you violate probation, there's some sort of, it's almost like when you go to the probation hearing for the violation from them removing your probation, it's almost like the same thing going through a foreclosure. They're foreclosing on you. And then they're putting you back in jail, putting you back as security. Like they repossessing the property. It's really weird once you start studying this, it really gets into the minds of these people, and you start to kind of like, these people still believe in slaveholding and shit. You know, it will make you kind of think, okay, I see, you know, but when they talk about white, but see, these people out here talking about white supremacy and stuff, but they really not able to articulate it just the way the mechanics of the sophistication operates. They just see some shit and it just inherently just feel some kind of way about it. But nobody's gonna come and point this shit out and break it down and show you exactly how they doing it. We need to read a B424 prospectus from the Correction Corporations of America. You see, I didn't did stuff like that. You know, you're not gonna tell me, oh, you know, they're getting paid for prisoners. No, do you know the per diem per bed that they get paid for a prisoner? They tell you it's in the public record. It's in the B424 prospectus. So right here, let's get back. Among these is an ancient statute of King Edward I, by which he ordained, with the consent of his barons, that the stewards of their courts should not hold plea of anything concerning merchants or mariners, whether it be charter parties of vessels, obligations, or other deeds, even though it should be under 40 shillings. Otherwise, they should be proceeded against by indictment, and if found guilty by a jury of 12 men, they should be imprisoned at the discretion of the High Lord Admiral. Ain't that's just like the common law. You get an indictment and you get a 12-man jury. In the reign of Edward III was made the celebrated Inquisition of Queensborough, which is to be found in Zouch's jurisdiction of Admiralty. I don't know what that is. It contains a list of offenses which the Court of Admiralty had from the time immemorial had authorized to inquire and punish. And among these is that of judges entertaining pleas of causes belonging to the admiral and of such as in admiralty causes suing the courts of common law. And this is what the case law is going to show you. In the case law, it's going to be somebody got hit on a ship and got attacked and got injured, and you're going to see they charge them some money for it. They charge them money for it. You say, oh, you injured another seaman. He got hit in the head, split his head open with something. And they say, oh, well, you know, that's going to be like, you know, 20 gold pieces. Oh, you can't pay it? Lock his ass up. Oh, you kill someone? That's going to be 100 gold pieces. You can't pay? Up, lock his ass up. Oh, you stole something? That's going to be 30 gold pieces. Up, you can't pay? Up, lock his ass up. If you don't think everything is about money, you's a damn fool. You living in some fantasy land. You's a damn fool. If you don't think it ain't all about money. This is all about money. This was not, we presume, directed against the king's courts, over whom we do not think that the Lord High Admiral ever claimed any jurisdiction or control, but against the multitude of inferior courts which England was filled at that period. All right, so it wasn't over the king's court. We're talking about the Lord High Admiral. The Court of Admiralty indeed claimed to be and was then considered as one of the king's superior courts, and as such exercised the power of checking and controlling inferior jurisdictions, and particularly the barons' courts, which at that time ruled almost omnipotent within their respective precincts. These barons' courts went unchecked. I'm telling you, when you study the history, now you can see these county courts, how they operate. You begin to see what they patterned everything after. These feudal jurisdictions. It's the same shit going on today. But they just call it superior court, state court. You know, they got these names for them now. The sturdy barons could not submit to be checked in the midst of a judicial career which was so profitable to them. This is profitable. Having their own courts is profitable. It's still profitable today. Go in DeKalb County on a Friday or some day like that. You go pay your ticket. Look how many people in there. You ever been to go pay your ticket and you walk in there and the motherfucker jam-packed? They making money. They making money. You on a court, you making money. The sturdy barons could not submit to be checked in the midst of a judicial career which was so profitable to them. For it must not be imagined that they were very ambitious of the empty honor of administering justice to their inferiors. The same thing they do today. They're administering justice to their inferiors. Watch Judge Judy, watch them court shows, and see whether or not you start getting the sense that, oh, these people, they the superiors and they administering justice to their inferiors because you don't know how to act. You don't know how to stay together and take care of your children. You just like godless people. You start watching the court shows and these damn the paternity test shows. You're gonna get the sense that these are people that are adjudicating things over heathens. But a war of confiscations was then waged by the lords against their vassals. The church on the one hand, and the nobles on the other, by means of their judicial establishments, vied with each other in rapacity. So the church and their courts went against these other barons, and rapacity means greed. The church is just as greedy too. They just as greedy too. Even down to the days of Lord Coke, it was a current saying that quod non caput Christus caput fistus. I forgot what that means, but it's something about the church is going to get theirs or something like that. I forgot what that means. This right here, this word right here, it's a Latin term. I looked it up a while back. To secure, therefore, forfeitures, waifs, you need to write these words down. Forfeitures, waifs, strays, herots, deodines, and a variety of other feudal perquisites. Those are benefits for having your court. Those are the things that fell under their jurisdiction. You need to see if any of those words apply to you. Like people who are lost or strays, or go and look these words up. And these are the words I'm talking about you need to study so you can bring them forth to today. Was the real reason which induced them to keep that power in their hands. They making money. Their obsequious stewards, appointed by the lords and removable at their will, seldom failed to decide similar causes in favor of their imperious masters. How you gonna beat the state when the prosecutor works for the state, your public defender works for the state, the judge works for the state, the sheriff works for the state, the police officers work for the state? How the fuck are you supposed to win? How are you supposed to win? No wonder they got a 98% win rate. You're not going to win, nigga. You're not winning. I like that. Yogi Freeman, minors, infants, and orphans. Very good observation. That's what I was looking for. Stuff like that, bro. Stuff like that. You on point. You on point. You're on the right road. You're on the right road. Let's keep going. Among those perquisites, not the least important to them, was that of Rex. Write that word down. Rex. Write all these words down. I'm gonna try to publish a list of them and put it up. But you need to write. This is what I mean why it takes time, because you got to stop, look all these words up, then come back and read again. Stop, look these words up, come back again. Stop, look these words up, come back again. You win, you got to have a win-win situation. One of the things somebody said, how do we win? How do you win is you got to let them win. You cannot, if you go in there with a win-lose type mentality, you're going to lose every time. This is why I'm always referring you to creditors and their bonds, because that is what that is talking about. This is what the acceptance for value is talking about. This is what this is not arguing jurisdiction is talking about. This is what it's talking about. I'm not going to challenge the facts of the case and things like that. It's a win-win what you're seeking, because what these people are $31 trillion in debt. You have an exemption that is unlimited. They are looking at you as the creditor. You're the person with all the money. All commerce revolves around signatures. If people stop signing papers, all this shit in America will cease. You stop using your signature. They can talk all the shit they want to. Let a week go by and don't nobody sign nothing. We'll see who have the power. Among these Percocets, not the least important not the least important to them was that of wrecks, and they seldom failed to appropriate to themselves the vessels and goods which were unfortunately cast upon English coast. As wreck was within the proper maritime jurisdiction of the Lord High Admiral, you need to write that word wreck down. He interfered with them, not with the view of rescuing the shipwrecked property for the benefit of the owners, but in order to attain it himself as a droit of his office, a benefit. This word droit, I want you to write this down. This is where the word legal fiction comes in. This is a fiction. At that time, several of the maritime towns enjoyed franchises of their own. Notice we talk about franchises, had their own court system, and were exempted from the jurisdiction of the feudal lords and their stewards. There, the municipal authority, whose manners were softened and refined by the plastic influence of commerce and their fine arts, preserved such shipwrecked property as came within their bounds and restored it to the lawful owner. To them, the exercise of that and other parts of the admiral jurisdiction became intolerable, and in the reign of Richard II, they laid their complaints before Parliament. The barons, as many may be supposed, lent them a ready ear, and their remonstrances speedily procured the famous statute of the 13th of Richard II, by which wreck was among the other things expressly excluded from the jurisdiction of the Court of Admiralty. By the first of these statutes, it was enacted that the Admiralty should only meddle with things done upon the sea, as had been used in the reign of Edward III, and by the second, that he should not have cognizance of contracts, pleas, and quarrels, and other things rising within the bounds of countries, nor wreck. Okay, now notice this. This is where we get into this thing. What is Admiralty? Is it the law of the sea? This is what they're going to talk about right here. It seems, however, that notwithstanding these statutes, the Court of Admiralty continued to exercise its ancient jurisdiction with but little interruption from the courts of common law until the reign of James I. That even in that reign, and while Lord Coke sat on the bench, prohibitions were not frequent. That in the reign of Charles I, the agreement which had been made under Elizabeth between the courts of admiralty and the common law for the settlement of their respective jurisdictions was renewed, and it was not until the reign of Charles II that a serious struggle took place between the two authorities, which finally terminated in the triumph of the common law. This is how the common law courts triumphed over the admiralty. The contest was maintained with great ability on the part of the civilians of Exton, Zouch, and Godolphin, all of them eminent jurists. In support of the doctrines which they defended, they displayed all the ingenuity and the force of reason, but although the weight of argument was manifestly and decidedly on their side, yet the superior power and influence of the King's Court of Common Law prevailed. But the works of these civilians may be consulted with great advantage by those who are desirous of becoming intimately acquainted with the nature and extent of the ancient jurisdiction of the English Court of Admiralty and the usurpations, for so they must be now called, of the common courts of common law. They demonized in the common law courts. They interpreted the statutes of Richard in such a manner as not to leave the Court of Admiralty any civil jurisdiction whatsoever. This was an interpretation which could not have been the intention of the framers of the law, who undoubtedly meant to leave them, except as to wreck, the same jurisdiction which they had exercised in the reign of Edward III, and we have seen above what that was. But the courts of common law determined that if a contract was made at sea, here it go, but the courts of common law determined that if a contract was made at sea, but to be executed on land, or made on land to be executed at sea. In either case, the common law had jurisdiction exclusive of the admiralty. What contract then were then to be remained within the jurisdiction of the latter? Who can conceive of an idea of a contract made at sea and to be performed at sea? An instrument, for instance, made in one latitude to be executed in another. And that's what they were talking about. What y'all talking about is just the law of the sea, but it has to do with the sea. This is what they what they're about to talk about. The civilians more rationally interpreted the statute to mean by things and contracts done at sea. All right, those things and contracts, which although the instruments by which they were proved may be made on land, yet are of a maritime nature, are usually performed at sea, such as contracts of affrayment and the like, of the cognizance of which the admiral was clearly possessed in the reign of Edward III. All right, so what they're saying right here is you have contracts made on land if they're in the nature of admiralty. What did we say? What did we say in the beginning? We said, okay, Your Honor, okay, there are two criminal jurisdictions. One is under the common law, and the other constitutes a condition of contract under criminal aspects of a colorable admiralty jurisdiction. Okay, under which two contracts, it was a contract made. Okay, so if you got me under a contract made on land that is in the nature of admiralty, there's a colorable admiralty because the legislature wasn't granted under the Constitution an admiralty jurisdiction. That was reserved to Article 3. So that's why we're calling it colorable. Okay, it's a colorable admiralty jurisdiction. Okay, so it's some sort of contract which cannot be a contract because there isn't any money to make it a real contract. There's no money. So it's a colorable contract, and you're in a colorable court under colorable law, utilizing artificial persons. The straw man. Listen, y'all. I'm going to pause right here. We're going to come back tomorrow because I'm getting tired. But we're going to come back. We're going to finish this. I might come finish it tonight. But listen, y'all. I'm not crazy in what I'm saying. You go and study this for yourself. It took me about 6 weeks to break this document down. Reading it every day, taking my time, writing down definitions, cross-examining things, looking through the dictionary. I didn't rush through this. I'm really rushing through it now. I'm rushing through it. But it's because I want to get to everything. Because I'm live and I'm trying to compress 6 weeks of study and probably about 6 hours of a presentation. But it would behoove you to study this document and get educated and start to, if you got an indictment, you'll start, you'll start to see it. What are they doing? This is why they don't like secure party. They don't like you filing a UCC1. They don't want you to be first in line, first in time, because you're blocking the ability to make money. Because money is made by attachment of liens. And if they can't put a lien on you, they can't make no money. That's it. But you don't want to be looked at as an enemy of the state, because if they can't make no money off anybody, they got the national debt they got to contend with. That's why we're accepting things and we're coming in and being the creditor and saying, hey, look, I know you don't know how to handle your business. Y'all people in government, y'all really don't know how to handle y'all business like that. Y'all $31 trillion in debt. And I know you need my signature on some of this stuff. So here you go. I'm going to write you out a negotiable instrument. You can monetize that, place it on your books, and offset whatever amount is needed. We playing a game of Monopoly. That's all this is. Ain't no real money in this system. This is a big-ass Monopoly game that they need to keep control of so that the system we can't allow the system to collapse. They're not going to let that happen. They're not going to let that happen. They'll violate you, any laws, whatever they need to do to prevent that from happening. So you need to be aware of that and move accordingly. They're not letting you just tear down the system. That's not happening. Anyway. With this, we will get back to it tomorrow. We'll get to some more questions. I can, I can't get to some questions today. I want to remind everybody on the 5th and 6th in Dallas, Texas, if you want to be with like-minded people, that's why you come to Dallas, Texas. Dallas is a beautiful city. It's one of the most beautiful cities in the nation. Come to my city. We're going to party on Sunday. I'm going to take y'all out somewhere, a nice place on Sunday. I don't know if you're white, you might want to go, you know what I'm saying? But I'm going to invite the white people to go. You know why? It'd be nice. It'd be an eclectic selection of people out there. It's in a white area, you know what I'm saying? But it's going to be packed. It's going to be packed on Sunday afterward. We're going to have a good time Saturday and Sunday. Come and get with like-minded individuals. That's what you're supposed to do. Y'all supposed to meet up. You come to events like this so you can meet like-minded people, man. And if you're a government agent, we're not going to be having an event to try to take over the government. I mean, if y'all want to come, fine. I don't care. I know y'all watching me and got people on me and everything like that. I'm not an enemy of the state, but I am a person that is supposed to come and tell the truth and give people, because the truth is going to be known all over the world, and then the end will come. Because I see what y'all are doing, and these people deserve to know the truth. They deserve to have the information so they can make a decision for themselves. You made a mistake arresting me. My family got destroyed because of some of the bullshit that you did. I'm telling you, agents, right now on what you did, because it still burns in my chest, some of the things that happened to me. And it has not subsided in over 20 years. It has not subsided. I have children, and you have other people that have children. And sometimes you can do things to the wrong fucking person, man. Peace to the gods. I'm out.